Yeah, so go ahead and let's do this, guys. Let's have everybody mute themselves until you have a question, at which point feel free to unmute and just jump in. We'll try to take some pauses to allow opportunities for questions, but unfortunately we can't see you, so we can't see you raising your hand. But we'll do our best to answer all the questions you have. For those of you who don't know me, I'm Scott Drucker. I'm the General Counsel and Assistant CEO with the Arizona Realtors, and I am joined by Nikki Salgat. Nikki is our Assistant General Counsel. And we want to talk with you today about what's going on in our current market and some of the tools that we're able to bring to you through our association in response to the current situation we find ourselves in dealing with the coronavirus or COVID-19. I want to start by talking about, and let me back up for 1 second and just make it clear that this is new territory for all of us. This isn't something that we were prepared for any more than you were prepared for. So we are learning as we go. We don't have all the answers. We don't know everything because, again, this is new for us too. So if you have questions and we don't know the answer, we will either find the answer for you or we'll try to direct you to the proper resource. Anything you want to add on that, Nikki?
No, I think that's said perfectly.
Okay, perfect, guys. So we want to start by talking about the COVID-19 Arizona Realtors Relief Hotline. This is a new member benefit, free new member benefit that was launched earlier today. And it's similar to the legal hotline, but the difference is that unlike the legal hotline, this is a hotline that is available to all 53,000 members throughout the state. The purpose of the hotline is to provide members with help navigating and applying for financial assistance programs during the COVID-19 pandemic. So financial issues that are personal to you. So whether maybe that's unemployment benefits, maybe that's SBA loans or the Paycheck Protection Program, it is not there to address transactional issues, okay? That we have the legal hotline for that. You have your broker, you have your office managers, et cetera. Still continue to go to those resources for transactional issues. But to the extent that there are financial issues that are impacting you personally as a result of the pandemic, we have developed this new hotline. The hotline, as I said, was opened today. They have been extraordinarily busy. The hotline can only service 30 people at one time. And some of the calls have dropped because we've exceeded that 30-person limit. So if that happened to you, I apologize, but I'm sure it'll slow down in the days to come. When you call the COVID relief hotline, the first thing you're going to need is your NRDS number, because we just need to make sure that you're an active Arizona Realtor, because that's who the hotline is available for. If you don't know your NRDS number, you can contact business services at the Arizona Association of Realtors. You can just go on our website, or you can email them directly at support@aaronline.com, and they will give you your NRDS number. At that point in time, once you give the NRDS number, you're going to be placed in a queue, and you're going to wait until it's your turn. And obviously, as I said, we've been very busy today, but the hope is it'll be easier to get through moving forward. They are not going to answer unrelated questions. So in other words, it's not an end around to the legal hotline. It's really just for the purpose of personal financial questions. The hotline is going to operate every day, 5 days a week, except for holidays, 9:30 a.m. to noon, and 2:00 p.m. to 4:30 p.m. So that's going to be 5 hours a day. Let me give you the phone number for it. It's probably the most important piece of information, right? It's toll free. It is 1-833-431-INFO. So INFO, which is also 4636. Nikki, go ahead. What should we talk about in regard to the hotline?
Well, I mean, clearly, as you said, that if you're in queue, please be patient, because if there are more than 30 people, so I think ultimately understand that in the beginning, it's going to be inundated with phone calls. So please be patient with us and allow Rick's firm to be able to handle the calls, and they will do so in a timely manner. And then we know that it's frustrating, and everybody wants to be able to have that access and to be able to find out how they can, what actions to take moving forward with regard to, filing for unemployment or whatever the case is. But, know that they're doing their best and that they will get to you.
Yeah, and so as Nikki referenced, the hotline is staffed by attorneys at the law firm of Manning and Cass. Unlike me and Nikki, they have far greater level of knowledge with some of these benefits that are available as real estate attorneys. This is not my strength or Nikki's strength. It's just simply not the focus of our practice, which is why we outsource this to a law firm that has a greater level of experience with these particular issues. The hotline, just also understand, I guess, that the programs that the federal government has put on, as well as the Arizona Department of Economic Security, they're working out problems as well. And it's not the hotline's fault to the extent that the SBA has run out of money for the small business loans. It's not their fault if the Arizona Department of Economic Security is not processing applications as quickly as they can. These sorts of benefits we know are available to independent contractors, including the unemployment benefits, which is fantastic. And we have our lobbyists, primarily Tom Farley, who has been in contact with DES on a daily basis to talk to them about the needs of our members and the experiences that they're having filing for unemployment benefits through DES. And there are definitely problems. There have been problems that we have relayed them to DES, and DES is aware of them, and they're working on making change, but it's a government entity, and that certainly takes time. Can we get some questions from you guys about this hotline? Any additional information you need or questions that you have about this? Nothing? We're clear on this one?
News.
Go ahead. Someone, who was that? Catherine, is that right? Nope. Sorry. Maybe someone else? Okay.
I don't see any questions. I've been reading the chat.
I didn't write one, but I have one.
Please. Who is this? Could you just say your name? Because again, we can't see you.
This is Catherine Gerhard.
Oh, okay. Great. Thank you, Catherine.
Technically, I have transactions in escrow, and I continue to work as a real estate agent. So how is it that I would qualify for unemployment?
Mm-hmm. And that's fantastic that you are having that positive experience. Unfortunately, there are other realtors that have been less fortunate. Their business has dried up. They've been unable to complete deals. They've been unable to secure business. And so really for the first time, even as an independent contractor, they have made unemployment benefits available. Now, obviously, if you are closing transactions and earning money, you're probably not going to meet the eligibility for it. But others maybe in the same profession may find themselves in a much less fortunate situation.
Yeah, and I think that's part of the reason why this hotline exists, Catherine, is so, for instance, if because this is new for independent contractors, they can call in and say, hey, tell me what are some of the qualifications to the hotline that I need to be able to show when trying to claim, unemployment. So like you said, you're already closing deals, so you might not be afforded that ability to apply for it, but they can at least maybe hopefully provide some parameters around what will allow for them to apply for unemployment.
Yeah, they should be able to give everybody a better understanding of the criteria. And it's not simply a matter of unemployment. Sometimes people will be making under a certain amount threshold, and that would render them eligible for the benefits as well. So that's kind of why we set up the hotline. And there's also, if you go to aaronline.com, that's our association's website, there is a section right on there that is titled COVID-19 or coronavirus information. And you go on there and it has an entire page and pages and pages after that of information, both about state information and resources, federal information and resources, industry news, that's both from the National Association of Realtors and from the Arizona Association of Realtors, and then a section of recent updates. It has several articles from me and Nikki. It has links to all of the government agencies, the relevant pages, so you could get on there and access Department of Economic Security and see the criteria right through our website, the links on our website. Or again, you can reach out to the hotline and they could guide you through that process. Any other questions on this, guys? And thank you, Catherine. Okay. All right. Well, let's move on to another topic, and I hope that you guys do find this benefit useful in the event that you need it. Hopefully, we're not going to be in a position where we need this hotline for very long. But for those members that are struggling and are in need of answers and for financial assistance, we have this available to you now. So hopefully everybody will find it beneficial. The next thing we want to talk about is the model COVID-19 certification for property access. This is a model form that Nikki and I drafted for the benefit of members. It is not a standard transactional form, meaning that it is not subject to copyright. You can take it and make changes to it, additions to it. You can give it to a seller, they can use it. Again, it's really just there as a tool for your usage. And the concept behind the form is relatively simple, and we understand that sellers are, and landlords, because it could be applicable to property management as well, are nervous about allowing third parties to come into their property. And they want to have some assurances from those third parties that it's going to be safe, that allowing them to come into their home, to come into their property is not going to put anyone at harm, is not going to put anyone at risk, et cetera. And so we've created this form. I understand that there's been some discussion based on a prior webinar in your area about the form, and some questions were raised about it. And so I do want to address those, because we were very careful to draft the form in a way that we think complies with all fair housing laws. And so I want to kind of walk through that with you. The first question that I guess is the criteria for all of this is, are we dealing with someone that has a disability under the Fair Housing Act? And we don't fully know that answer yet. Generally speaking, someone that has a flu and is exhibiting flu symptoms does not qualify as disabled under the Fair Housing Act. Personally, I think that if someone, even if they have COVID-19, if they're in as good a shape as necessary in order to go out and look at homes, and to be knocking on doors and going into properties, they're probably not disabled from the standpoint that their COVID-19 hasn't limited a major life activity. We understand that we may be getting some more information from the federal government in this regard as to the nature of a possible disability. But I'm a little skeptical as to whether this would result in a disability. But I think for the standpoint of the rest of this conversation and discussing this form, Nikki and I will assume that the person that is seeking to enter the home is disabled. Nikki, do you have anything to add on the question as to whether someone is or is not disabled under the Fair Housing Act?
No, I think, yeah, you've stated it well enough. We've held many conversations on whether or not we believe. I mean, granted, we would have to wait to see if ultimately it is decided that this is considered a disability. But like Scott said, currently we don't have anything that says it is considered. Having COVID-19 is a disability, and therefore, we can't necessarily opine one way or another. But at this point in time, it's not considered a disability.
But let's assume, let's err on the side of caution, and for the rest of the conversation, we're going to assume that someone is disabled, okay? But yet we still want to screen them. We still want to make sure that before they enter our property, that they're not going to be contagious, that they're not going to subject the homeowner or us as the listing agent to any sort of threat. So let's assume that even if they are disabled. Well, I think the first thing to talk about is something that's called the direct threat analysis. And this is essentially, and someone put on here, where is a copy of this form? Sorry, I should go back and just say it's on aaronline.com. It was published a couple weeks ago in The Voice, but it is on aaronline.com under the COVID-19 section. You can find it on there. If not, email me afterwards and I'd be happy to send you a copy, but it is on there. So let me get back to the direct threat analysis. Understand that there is nothing in the Fair Housing Act that requires you to allow housing or tenancy to someone who constitutes a direct threat to the health and safety of others. Sometimes we see this in regard to a person who's acting in a violent manner, but can also pertain to a contagious disease. And so you do, as a homeowner, or as a listing agent, or as a landlord, have the right to screen to ensure that someone does not pose a direct threat, meaning that they're not going to subject someone to illness, or in this case, contagious, and so that the homeowner would contract COVID-19. The key here, though, is if you're going to do this, you have to rely on objective assessments, and you've got to apply them universally, right? You can't have someone walk through the door and say, well, you look like someone that may be at a high risk, so I'm going to ask you to fill out the form and certify that you don't meet any of these criteria. that would be unacceptable because it would be profiling. You can't say to someone, oh, well, you've got children, and so I'm gonna ask you to fill out the form because I feel because you have children, you guys may be at a higher risk. Again, that's not going to work. You have to have everyone, if you're going to use the form, you have to have everyone use the form, not just people that you think may be at a high risk. But you do have the right to screen someone under the direct threat analysis. Nikki, you want to jump in? Anything you wanted to add there, Nikki, on the direct threat analysis?
No, I'm sorry, Scott.
Okay, no problem. So then the next thing, if you think about the form itself, because one of the objections or the questions that we had raised is, well, can you just go around asking someone, hey, do you have COVID-19? And that's a good question because, again, it gets back to whether whether they have a disability or not, whether they're disabled. And generally, you can't ask someone about the nature of their disability. But if you look at the model COVID-19 certification for property access, it doesn't actually ask any questions. What it does is it states criteria that have to be met in order for you to allow the person to access the property. So as long as they meet all of these criteria, they sign the form and they're allowed in. If they don't meet the criteria, they would not be allowed access. But let's say someone comes in, they look at the form and they can't sign it because they have had contact in the previous 14 days with someone diagnosed with COVID-19. So they would not meet the criteria for entry and they would have to turn away. The homeowner or the listing agent, you wouldn't know why they were walking away. You haven't asked, right? So you're not asking about the nature of a disability. For all you know, they could have COVID-19. They could have been in touch with someone that had COVID-19. They could have traveled to China in the last 14 weeks. We simply don't know. And that's the point of the form, is it's not asking specific questions. And I know that, Nikki, that's something that we've had a lot of discussion about in formulating the form because we wanted to err on the side of caution in the case that someone does have a disability, that we're not violating their privacy in that regard.
Right. So we know that NAR has opined that maybe, to not be asking individual health questions. And, we have held conversations regarding whether or not we feel that this, puts somebody on the spot to disclose something about them individually, their health concerns. And because there are 6 different qualifications for whether or not you allow them to enter the property, and it isn't directed at that particular individual. It's multiple categories that we're asking them to fulfill. So we don't think that that's going to be an issue with learning this health information.
Yeah, I don't think there's going to be any discrimination based on a disability, because again, even if they have COVID-19, for all we know, the reason they're turning away is for a completely other purpose. They don't meet an unrelated criteria. So that was our intent in drafting that portion of the form. And then the last thing on the form that I would note is there's a sentence that was added that says, if access is prohibited based upon the above, reasonable accommodations can be made to provide virtual access. This goes back to, again, the possibility that the person with COVID-19 is disabled. We know that when someone is disabled, we need to provide them with a reasonable accommodation. Coming into the property, if they pose a direct threat to you as a listing agent or the homeowner or the tenant, that's not going to be a reasonable accommodation. But there are reasonable accommodations that can be made, such as a virtual tour of the property, or they can come back after they've been symptom-free for 14 days, or whatever the case may be. But we do have something in there just talking about reasonable accommodation, because I think that that's important in the event that someone is deemed disabled as a result of COVID-19. Let's take some questions. Go ahead, Nikki. And then guys, think of some questions you have, and we'll let you jump in.
Oh, did you mention in the beginning how, because this isn't a required form, and it's up to the individual brokerages on whether or not they want to implement this. We know that a lot of the reasons that this form has was drafted in the first place is because a lot of sellers were concerned about who was entering their property, and they wanted to ensure their safety, and so it was out of precaution that it was drafted, and so that we know that we can have our clients feeling safe with regard to whoever's entering their home.
Yeah, and as the form states, it doesn't create a binding contract. It's really just to help put the seller and possibly also the listing agent at ease knowing that someone that is going to enter their property has certified that they've met all of these criteria. Because, we want to be able to continue conducting business. We just want to do it in a smart way, and we want our sellers to feel comfortable when they're letting people into the home. So go ahead and if you have a question, unmute yourself and let's talk a little bit about this form, if you would. So hard not being able to see you guys.
You're just that thorough, Mr. Drucker.
Yeah, there's no questions so far.
No?
No.
All right, guys.
I haven't seen any either.
Okay.
I have a question, Scott.
And who is this?
This is Paula Mack. I'm with Russ Lyons.
Paula. Yeah. Thanks, Paula.
Thanks for taking my question. And when I read we're talking about the model, right, that was sent to us for.
Yes, correct.
I think it's great to have something like that. But when I first read it, I know every time I go to a doctor's office, I'm given, it's the HIPAA thing to say that this is confidential information, and I sign it and read it, and I guess you can get a copy of it and take it with you, whatever. But my question would be, is this information considered confidential, and what's our liability for then keeping that? For example, when we get that survey back, what do we do with it, and what is our responsibilities for liability if we don't store that properly, and for how long, and all these other questions come into my mind, because I think this is personal, confidential information.
So that's actually what's unique about the form, is that there's nothing on here that is in fact confidential, because they are not disclosing any information. They are not disclosing any medical condition, any disability, anything of that sort. Rather, they're talking about the lack of it. So it was drafted specifically for that purpose, so that no one is putting down any information. All they are doing is indicating that they've met these specific criteria. No one has to disclose on here that they have COVID-19. No one has to disclose on the form that they've come in contact with someone with COVID-19. They don't have to disclose anything, any personal information, anything about their health or conditions. They're not disclosing that to you. They're simply saying, I meet these criteria, and therefore I am able to enter the home. I think that the form is a little more symbolic than anything else, designed to put the parties at ease. I don't think that agents really have a lot of liability in this area, which is the reason why we haven't drafted some sort of waiver. Michelle Lind, Nikki, and I have had a lot of in-depth conversations with Katie Johnson, who is the General Counsel at the National Association of Realtors, and other NAR attorneys, about whether a form is necessary. And we kind of are all on the same page that a waiver form, formal release, really isn't required under these circumstances. Number one, I don't. The risk is open and obvious. Everybody knows that you go out in public right now, there's a possibility that you could contract COVID-19, and you don't have the obligation to warn someone against things that we all know exist. Second, I don't think that and we don't think it's the agent's responsibility to ensure someone's health and safety from the standpoint of an infectious disease. That's really beyond your scope. So we've got, in order to prove negligence, you have duty, breach, causation, and damages. I don't think there's a duty, and so I don't think you're breaching a duty. And as for causation, I think it's impossible to prove. Let's say someone, 14 days later exhibits symptoms of COVID-19 and they test positive. How are they going to be able to prove that it came back from when they entered this property? You can't. And so from a causation standpoint, I just don't see any successful claims. And I think that the liability on the part of the agent is extremely limited, if non-existent. And that's, again, both my opinion, Nikki, Michelle Lind, and the attorneys at the National Association of Realtors. Nikki, you want to add anything there?
Yeah, no, I know that, that's what we were trying to address when we said we're not asking individual health questions. And, ultimately, again, we've driven this form down to that, HIPAA applies to healthcare providers, and we're not worried too much about with regard to the disability. We don't want to have discrimination with regard to a disability. Right. And that's really what this form was, it's set there for, is to make sure that first of all, make sure you apply, if you're going to apply this form to one, apply it to all, anybody that enters
Right.
the property, right? So that we don't have to worry about fair housing or any type of discrimination. And thereafter, of course, as Scott said, we added the verbiage for the disability. So that at least you're telling them, if you can't see the home, we're going to provide alternate means for you to do so.
Right, a reasonable accommodation.
Right.
So Paul, I hope that answers your question.
It does.
Anyone else want to?
It
Okay,
does.
great.
Thank you. And so what you're also saying, which is important for me to hear, because I just want to make sure that as long as I present that to all buyers agents who want
Yes.
buyers to view the property, then
Right.
I'm in good shape. Is that correct?
Yeah, you're right. You can't do it on a selective basis, because then, if there's profiling involved and possibility of claims of discrimination, again, you can't give it to people that have kids, because you could be discriminating based on familial status.
Okay.
And so you just have to, whatever you do it universally. And that's of course how you stay out of trouble.
Okay, thank you.
So someone here asked, does reasonable accommodation have a time constraint? That was Dusty. Thank you, Dusty. No, there's nothing in the law that defines what the term reasonable, right? Reasonable is going to be a very fact-specific analysis. It's going to apply under different scenarios in different ways. Maybe they are adamant about seeing the property in person. Well, what would be reasonable then? Well, I think reasonable would be after they've been completely symptom-free for 72 hours, according to the CDC. Or they've gone more than 14 days without coming into contact with someone who has contracted COVID-19, or it's been more than 14 days since they returned from a country that was identified by the CDC as a level 3 high risk. So it really is going to depend on the specific nature of the issue. Now, if they said, well, we'll be okay with video, we'll be okay with a virtual showing, could you then wait 3 weeks? Probably not, right? Because that would not be reasonable. If you're going to do a video, there's no reason that couldn't be done within a matter of days. So I hope, Dusty, that answers your question. Anything to add on that one, Nikki?
Yeah, no, I think that that's correct, right? It just depends on the facts of each circumstances. Even with what you say about with a video. What if the homeowner had COVID, and then of course then it would be reasonable that you wouldn't enter the premises until
Right.
14 days later. So I think it just depends on the facts that surround each instance.
Right. Any other questions? Gary Nelson, thank you for your point. Anybody else have anything on the model form before we move on? Going once, going twice.
Should I play music for you?
Sold. All right. So let's talk about the other form that we've developed, and this one is a standard transactional form that's now in our library. Well, actually, you know what? Should we talk about this one first, Nikki? The COVID-19, the coronavirus COVID-19 addendum. Okay, you want to introduce it first?
Sure. So I don't. And this is where it's hard when you're talking to people, because I usually like to interact a little more. Like, how many of you guys have been using this? So, ultimately this form was created in March, right in the thrust of when laws were changing, and we didn't know what was going to happen from day by day, hour by hour. And ultimately we were having contracts that were starting to fall through. People were getting scared, didn't know what was going to happen, what the future held, trying to find an alternate means of getting out of a contract. And so, the membership, a lot of the membership, I think, contacted Scott and really pushed for wanting AAR to create an addendum to help them out so that they could help put the buyers at ease. And in my understanding now, even with after the form, that everything is still going fairly well in the market. It's slowing down with regard to showings and stuff, but everything is continuing. And so ultimately what happened is, we created this form because we wanted to give the parties the option. So I don't know, do we want to go step by step through the form?
Yeah, I mean, I think a couple intro notes also would be that understand that the form is not required. The parties aren't required to use it. One party cannot make another party use the form. You as agents cannot make your client use the form. It's an addendum, so it adds and changes terms of the purchase contract. and it has to be agreed to by the parties. If the parties want to use it, they can use it right at the beginning of the transaction. They can use it at the time of contract formation, or, circumstances may arise, halfway into the transaction or at any point prior to close of escrow, and they may decide at that point in time that I want to go ahead and use the form. And I'll let Nikki, we're not going to spend too much time because I think you guys are familiar with this, and so she can run through some of those boxes quickly. But one point I do want to add is understand that you should never have multiple boxes checked other than the additional terms and conditions box on line 33. So you can have the box on line 33 checked as well as one of the other boxes, but of the first 4 boxes, you should never have more than one of them checked at a time, because that would mean that they're in conflict. So Nikki, you want to just run through those quickly, and then we can see what sort of questions, and if there's none, we'll move on.
Sure, of course. So I'm just going to go through the options, not the part. So, well, in the beginning, we have that reminder. So we found that sometimes people are using the form not to the way that we drafted it, right? But there have been some people that have been using the form just with the initial verbiage that talks about, hey, this is a pandemic, this is unprecedented, we don't know, make sure you seek the advice of other professionals. And it was just another reminder to the parties to say, hey, this is, this is new, but you should seek other advice outside of your real estate agent, if it's outside their scope of business. But so the 4 options that we have are the first option is the parties can either just automatically decide to postpone the close of escrow date and extend it, and then they can put a date certain at the end of it and say, okay, we're both comfortable with, 45 days from now. Right now, we're just not comfortable with what's going on. We're going to go ahead and extend that close of escrow date 45 days. The second option is essentially what you're saying. Now, if anything happens to any of the parties that can effectuate this transaction, say that there's a possibility that they become that mandatory isolation due to COVID or voluntary. And I know that there's an FAQ on this question. So what is voluntary? Well, we know that right now the supplies are limited and who can be tested and how many people can be tested. And so, if you've known of somebody that might have been diagnosed with COVID-19, or you've gone to the hospital, but they can't test you, and they're saying, go home and quarantine yourself for 14 days. We think that was the appropriate thing to do, was to allow that option, because parties might be voluntarily quarantining themselves due to a possible exposure, or we're thinking not being able to be tested. So ultimately what that does is it extends the time frame for close of escrow for it to say, okay, 10 days after the quarantine is over, we're going to go ahead and close escrow at that point in time, but we're going to wait until you're clear of the quarantine, or the closure is lifted, which currently is the end of this month, right? The third option, and I'm sorry if you guys can hear my dog, the third option is essentially the same, where the parties extend again for voluntary or mandatory, anything affected by COVID-19, except for there's a cap on it. So in other words, it's only going to be extended for a max time of 30 days. And beyond that 30 days, at that point in time, then either one of the parties can decide to cancel the contract, and the buyer receives their earnest money, and the contract is just over if they decide to choose that option.
Nikki, let me jump in real quick on that third option, because I'll tell you guys, I'm not a fan of the third option. If I'm a seller, I don't necessarily know that I'm agreeing to the third option. The both of the options, the second and the third option, extend time for performance. But what the third option does is it also completely excuses performance. That's a tough one for a seller. And so you got to make sure that if your sellers are going to be checking that third box, that they understand that they're letting the buyer out. They're giving the buyer the option just to walk away and say, deal's over, I get my earnest money back. So I know that there are times where, a seller feels bad, the buyer's encountered something and they're willing to do that. And that under those circumstances, maybe that third box is appropriate. But it's a tough one for me. It's a tough sell for me. And it wouldn't be my favorite course of action. And one of the questions that I think Nikki and I get is, well, what if the buyer just simply comes to you and says, well, I'm worried about the economy, and so I want out. Can they get out? And the answer is no. There's nothing in the contract that allows for that. Now, if they were affected by the economy to the standpoint, from the standpoint that maybe their financing falls through, well, yeah, their financing contingency could, the deal could fall apart based on that. But otherwise, the answer is no. They can't just simply walk based on a fear of the economy or concerns about moving forward. But that could change if you're using that third option. So be very careful about that one.
Mm-hmm. Yeah, and I'm with you, Scott. I'm that's not something that we necessarily thought would be a good option, but there are parties that, and members that may potentially want that. And so it was included for that reason. So then the fourth option is that the buyer and the seller can decide to just cancel the contract and the buyer receives their earnest money deposits. And then the last option, of course, Scott said, don't mark any of those first four options unless, there should be no more than one option marked, unless, of course, you are adding additional terms and conditions to whatever it is that the parties ultimately decide they would like to add, as long as they're not conflicting with any of the boxes that you previously checked.
Right. And it's possible that you may enter into this form at the beginning of the contract and check the second box, and then halfway through the contract, the parties want to cancel. And so now they want to exercise the fourth box. So what do? Well, I think at that point in time, you execute an entirely new COVID-19 addendum. You don't use the same form and try to change the box. You would execute a new COVID-19 addendum to effectuate that cancellation. Let's stop for a minute, Nikki, and see if anybody has any questions on this form. I think a lot of you guys have received instruction on this form before, but as the authors of the form, Nikki and I are happy to answer any questions that you have. So if anybody wants to jump in, we'll give you a minute. You guys good? Ben, Brenda, Brett, Bruce, David, Dustin, Dusty, Gary, everyone good? So hard not to know. Thank you. Did anybody have any questions on that one? We just need to make sure the rate will not expire. The buyer may not be able to qualify for the loan. That's a great point. And we talk about this all the time in our industry about the importance of communication, especially amongst industry partners. And now it's never been truer. You're going to need to be in touch with title. You're going to need to be in touch with the lender. And ensuring, if you're going to be extending this out, that the lock is not going to expire. That's a great point. So thank you for that. Who was that? Was that Norma? Thank you, Norma. That's an excellent point. All right. I want to. There's nothing else on that one. One other topic that I want to just jump to really quickly is the topic of the shelter in order that Governor Ducey issued. We know that Governor Ducey came out with Executive Order 2020-18, which was basically the stay home, stay healthy order. But we also know that prior to the 2020-18 executive order, there was another executive order that was 2020-12, and that was the one that defined essential services. And for weeks before that executive order came out, we at the Arizona Association of Realtors lobbied very hard with the governor's office to make sure that real estate and real estate related industries like appraisals and title were included as an essential service. We were successful in our lobbying efforts, and so when the stay-at-home order came out, our business was still allowed to proceed. And we got a lot of questions about that, and whether, well, is that a good thing? Is that the right thing? Should we be deemed essential? And so I want to share with you kind of our reasoning and then talk about what you guys can do and maybe what we should be doing under this. I think it's important for a number of reasons that real estate was deemed an essential service. First of all, the real estate industry is essential to the economy of the state of Arizona. Our population is ever increasing, and housing is big dollar business. And to have that come to a grinding halt would negatively impact the economy in ways far surpassing, I think, what we're seeing now. The second point is we've got hundreds of thousands of people that are involved in this industry. We've got 80,000 plus real estate licensees, and that, and then figure on top of that, appraisers, home inspectors, lenders, escrow. that's hundreds of thousands of people that would be put out of work if our industry wasn't allowed to continue to operate. Again, that would be very harmful for the economy. And then I think that the final point is that housing is important, especially now. I mean, people need a safe and secure place to provide shelter and so they can stay safe and hopefully avoid contracting COVID-19. And so for all of those reasons, we thought that being essential and being named an essential service was very important. But with that said, is it business as usual? Should it be business as usual? And the answer to that is no. And this is something that Nikki has written about and I've written about and we've thought about a lot, because even though we're essential, we're leaders in our community, and we need to act in that manner and lead by example and show that we can conduct our business, but do it in a socially responsible way. And Nikki, you can talk about some of the ways that our members are going about doing that, and how we want them to do that and not abuse our rights to continue to conduct business, because if we do, we could lose the privilege. And so everybody has to be smart about how we're conducting business. And I know you've written about that quite a bit.
Mm-hmm. Yeah, so I think that with regard to showings, I've heard more and more everybody. I think with the way it currently is, initially, we talked about, yes, still continuous showings and taking people through a home, but that's why this certification for property access was created, and people are more erring towards the side of 3D virtual tours. I don't know what kinds of systems out there necessarily exist. I've seen different ones from 3D to people just using FaceTime, or we've talked about Scott using Zoom before and being able to record it, but part of that is in those safety precautions too. If you are doing performing an inspection or a showing of that nature that happens to be virtual, you want to ensure that you're being safe too with those practices, right? You want to ensure that you are asking the person on the other side of the tour, hey, what do you want me to point at? What are we looking at? Is there something specific that you need to see? And you want to ensure that you make sure you're covering all of of course, if someone's in the home, we have articles on our website that talk about what kind of good practices do you have with wiping down the doors, leaving lights on. So if someone is coming in for a showing, if you leave the doors open, leave all the lights on, you don't have to worry about you're taking those extra precautions to ensure that individuals aren't having to touch more items in the house than necessary.
Right. And I got some pushback. I got some pushback from members who said, I think it's irresponsible for you guys to have us deemed essential services, and our members are out there holding open houses, et cetera. Well, I've explained why we had the industry deemed essential, but everybody has to decide for themselves whether they feel that it's smart to conduct an open house, and obviously, speak with your seller to make sure it's something that they're comfortable with. I would probably argue in favor of showings by appointment. But that's not to say that you can't do open houses. But if you're going to do it, again, do it in a socially responsible way. Limit the number of people in the house at one point in time. Have people line up in a queue outside, in a line outside the front door, 6 feet apart before they can go in. There's ways to go about it, but doing it in a responsible way. Question: where can we get masks and gloves? That's a good question. I know that there's plenty of things online that instruct you how to make masks, but as real estate attorneys, that's one that's beyond us. I'm sorry, I'm not able to answer that one, Victoria. It's a good question, and maybe if anybody on here knows where they can get masks and gloves, go ahead and type that in, because that's not something that I'm familiar with. But that's a great way, using masks and gloves to help protect your clients and yourself. So any questions about open houses, essential services, things that you can do or that you're permitted to do, things that you can't do? Anything of that sort, guys? Just go ahead and unmute yourself and jump in, please. Nothing? Shannon? Shelby? Shelley? Nothing? Victoria?
Let's start in the middle of the
Okay. All right. Jessica, do you have a question? Just see if Jessica's there.
So Kevin said that he knows someone that makes them. So
Okay.
Kevin.
All right, so get a hold of Kevin. He might be able to help you. Nikki, let's jump to residential evictions quickly, and then we can see if there's other topics that people want us to cover. If not, we'll let everybody go. But we've got some great resources on aaronline.com on residential evictions, and probably the best thing up there is an article that you wrote that covers both Governor Ducey's executive order, it's 2020-14, which came out actually prior to the CARES Act.
Right.
But you want to talk about residential evictions and what's allowed and what's not allowed, and how it impacts property managers and tenants alike.
Yeah, so first and foremost, we know that, either if you're not a property manager, maybe you happen to be, a landlord, because a lot of people in real estate, they tend to buy properties and also manage them themselves. But ultimately, what's going on, and I think that there's some major confusion out there that exists because of the difference between what the governor, his executive order, and then federal law. So I'm kind of want to make the distinction for you guys so that you have an understanding. Is that first, the governor first came out with his executive order, and it's Executive Order 2020-14. And ultimately, that order was saying, hey, you cannot evict anybody for not paying rent if they, have been affected somehow by COVID-19. So in other words, if they lost their job, they've been financially harmed somehow due to the coronavirus, and they aren't thereafter able to pay rent, then you as the landlord or property manager cannot evict the tenant due to that reason. And also, so Scott mentioned earlier, you want to have a safe and secure place for housing, right? So if you have COVID-19 too, if you had the coronavirus, you don't want to evict somebody. They have to be able to be left in place. And the governor said, this is in place for 120 days. I don't believe we still have an exact idea of when that 120-day time frame started.
I think it started on March 24th. I think was the date, the start.
So they did say, well, because some people asked whether or not that 120-day was from the moment they were first told, or like when exactly the time frame started. So, so essentially, if you had an economic hardship due to COVID-19, or you were diagnosed with COVID-19, then there's no way that you would be allowed to evict a tenant. Now, if you needed to evict a tenant due to some other contractual basis, so in other words, they breached the contract because they had, some other form. Let's say they lied on their application, or they lied on their they lied on the contract, you could still evict them for that. That has nothing to do with the reasons for why you could evict them.
Now, you could evict them under state law, correct?
Right.
Okay.
And so then that's where the confusion comes in, is because thereafter, Governor Ducey was the first to lay down some law regarding evictions. And then thereafter, the CARES Act, the federal government said, okay, you cannot evict anybody for non-payment of rent. And it doesn't matter if it's related to coronavirus or not, if you have a federally backed mortgage.
Federally backed mortgage, right.
Right. And now, so I think people were confused because, so this is in effect until July 25th, I believe.
Right. It expires on July 25th. And so the point is, Nikki, you're right. The federal law is far broader than the state law. So there are evictions that in theory would be allowed under state law, but they are not allowed under federal law. So even if, Governor Ducey were to, if his order were to expire, you still wouldn't be able to evict any residential tenant when there's a federally backed mortgage that's involved. So we've got two questions on here. First, Nicole said masks are not required. That's correct. Masks in Arizona are not legally required, unlike some other states. I think New York put that law in place. We do not have that in Arizona. Can a landlord charge late fees? No, you cannot charge late fees. You cannot negatively impact someone's credit. All of these things, they're protecting these tenants. And look, I understand the flip side of this is that it harms landlords, and I certainly understand that. We have a lot of resources on our website for landlords, for financial assistance for landlords. There is money there, money that's still available both for tenants and landlords. So have tenants look into that. If you're a landlord, have them look into that as well. Don't government workers still get their checks? Don't know that answer. Not sure. I don't know that. But again, even under the federal law, even if the person doesn't have to be financially impacted, they don't have to be impacted by COVID-19. The eviction moratorium is in place. Period. End of story. And that's really all there is. What about tenants in homes for sale who do not want anyone in their home and won't allow any access and won't allow the agent to make a one-time virtual tour? Yeah, that's a very, very difficult one, because they are obligated under the law and under the lease agreement to allow the landlord access with, I think it's 2 days. I can't remember if it says 2 days or 48 hours. I think it says 2 days advance notice. And if they don't, they could be in breach. Now, let's say there's no federally backed mortgage that's involved there, and the tenant does not have a COVID-related, has not been affected by COVID-19. You could proceed with an eviction. But if they have been impacted by COVID-19 or there's a federally backed mortgage in place, you're not going to be able to evict them.
Right.
That's just the way it's going to go. You with me on that one, Nikki?
Agreed.
Okay.
Yeah.
So if you do not have a federally backed mortgage, this one's Jessica, you can evict for non-payment due to loss of job. No, because the state law would prohibit that. Under the federal law, yes, but under the state law, because again, as Nikki said, while Governor Ducey's order is in place, and it's 120 days, I believe, from March 24th, you cannot evict someone who has contracted COVID-19 or has been financially impacted as a result of COVID-19. So under the state law, you would not be able to pursue that sort of eviction. Anyone else have any questions on residential evictions? And hopefully this will be behind us, quickly. We obviously, no one knows, but I hear from a lot of landlords and tenants, and it's difficult on both. And I certainly understand that. And it's hard for us at a state level to address with a form because the law is in flux. We don't know if these orders are going to be extended and to what extent. We know that the laws apply to some mortgages and properties and don't apply to others. So drafting a one-size-fits-all form it's proved really hard. I've spent a lot of time thinking about this, starting the draft and talking with other people about it, and it's just proved very difficult, which is why we don't have a form in place right now for that.
Yeah, and I think your best bet is to utilize those things that exist out there to help tenants with their rent, or a lot of lenders are also giving grace to the homeowners to kind of at least let them hold off on payments, even though they're still going to be owed, but take advantage if you're being harmed by this too, of talk to those lenders and see what they are offering.
Yeah, and understand, when we talk about the foreclosure moratorium, it doesn't excuse someone from making the payments. Okay, once this moratorium lifts, if they haven't made all of the payments, you can proceed with eviction. Nothing is excusing them from making payments. It's just prohibiting you from pursuing an eviction while the moratorium is in place. If you want more information on this topic, there's a great webinar that's on Arizona Association of Realtors Facebook page that was done by Denise Holliday. Many of you may know Denise. She's an attorney who is does property management law, represents a lot of landlords. And she's also a justice of the peace that handles evictions. So her insight was really fabulous. And that webinar is still up on our website. And so if that's something you want more information about, I would recommend that you go there. So Nikki, we've gone, it's now 3 o'clock. So we hit our 1 hour mark, which is longer than I thought we would go. Is there any other questions, guys? Any other topics that you want us to address before we sign off? Anything else?
Yes, this is April Knapp. Can you hear me?
Mhm.
Yeah, April, thank you. Go ahead.
Hi. Yeah, so I thank you for taking my question. I am primarily a property manager, so I have 51 rentals that I manage, and I just had my first case of someone pulling the COVID card for not wanting to move out of their rental at the end of their lease, and they didn't provide any documentation. Just to preface this question, this is a rental that is a summer home for one of my clients who lives in Phoenix, and she comes up during the summer, June and July, and stays in the home. So I only allow a 10-month lease from August to May each year. And the tenants knew that going in. They signed a 10-month lease. Their lease ends at the end of May. I just gave them their 30-day notice, and they responded with, do you want me to just read their response so I don't have to?
Go ahead and give us a summary of it.
I'll give you. So essentially, they said that, so the tenants are a gentleman who's a disabled veteran, and the wife is a school teacher. So he's pulling the stay in place order basically as a reason not to vacate the premises at the end of his lease. He's saying that the Department of Veterans Affairs has ordered stay in place so he cannot move. I don't see how that has jurisdiction here, but and then he also added that his wife has some symptoms and is being tested for COVID-19. So he's kind of pulling as many cards as he can here.
Yeah, that's kind of the shotgun approach, right? Throw everything against the wall and see what sticks.
And from the beginning, that has been the type of tenant this is. They have caused property damages due to negligence and all kinds of things. So the owner definitely wants them to leave, regardless of that. But they're even saying, oh, our realtor told us that you can't ask anybody to move out right now, so you should know this, kind of, because they're smarter than me. So there's a lot of things going on here, but I wanted to ask, is there any protection for him being a disabled veteran? Anything that says that someone cannot be asked to move out at the end of their lease during this time?
So, April, is there a federally backed mortgage that's attached to the property?
I am not aware of that, so it's something I'm going to have to ask the homeowner.
Okay. So that would be the first question, right? Because if there is, that's going to be the end of the story right there. You're not going to be able to pursue a foreclosure or an eviction for any reason.
Well, I mean, it's not an eviction. It's just a non-renewal at the end of their lease.
Right,
really.
but when they don't move out,
Right.
at the end of the non-renewal, you file for eviction, right?
Right. Okay.
And so it will ultimately come down to an eviction because they're not going to move out. So you're going to have to file for eviction. If there's a federally backed mortgage, you're not going to prevail. Now, let's say there's no federally backed mortgage, maybe the property's owned outright or whatever. If that's the case, they are going to have to be able to provide documentation showing that they have been affected by COVID-19. The shelter-in-place order in and of itself is not going to protect them. That order doesn't prevent people from moving. But if she can show that the wife can show that she has contracted COVID-19, is under quarantine, under the state law, that would prohibit you from moving forward with an eviction. So it's a really fact-based, it's fact-specific, the evaluation. But it sounds like you need some more information regarding the federally backed mortgage. And then if it's not a federally backed mortgage, have they been impacted and can they provide evidence of that?
Sure. Okay. So barring that this property is owned outright, I find out that from the owner, I think that is the case. So barring that it's not federally, assuming it's not federally backed, this property, they really don't have any claim unless she does show documentation that she has been quarantined due to being diagnosed with COVID.
Or financially
impacted. Yeah.
Right.
Okay.
So
they haven't cited any financial or economical hardships here. So I don't see, honestly, I expected this exact response when I asked them to move out. So I knew that they were going to pull whatever they could out of their hat and throw it at me.
Sure.
So
let me read for you, just so we're clear and we have it on the record, the criteria for the application of the state executive order. The order applies to the tenants if the tenant is required to be quarantined based on their diagnosis of COVID-19. So that's number one. Number two, the tenant is ordered by a licensed medical professional to self-quarantine. Number three, the tenant is required to quarantine based on someone in the home being diagnosed with COVID-19. So maybe, someone else that is living there with permission, that has COVID-19. Number four is if the tenant has a health condition as defined by the CDC that makes them more at risk for COVID-19 than the average person. And then the fifth one is if the tenant has suffered a substantial loss of income resulting from COVID-19. So, and you are allowed to ask for documentation, so that if they're claiming one of those things, you can ask for documentation and they would have to provide that.
Okay, so is documentation required for me to, I don't just have to take their word for it.
Correct.
Okay,
You do not have to take their word for it. And if
Okay,
you were to
so I
pursue
can
an
reply.
eviction, the court would require them to produce that evidence if they were trying to stop the eviction on that basis.
Okay. So if this is a federally backed mortgage on this home, I won't be able to proceed with even giving them a non-renewal notice.
No.
Okay.
You can certainly, you can give them the non-renewal notice.
Yeah.
And I would give them the non-renewal notice. And if they don't move, I would give them the 5-day notice, et cetera. But when it comes time to file for the eviction, you're not going to be able to move forward.
Oh, okay. I see.
But absolutely give them the notice.
I did actually listen to Denise Holliday's webinar, and she did mention that you cannot non-renew as well on federally backed properties. So I don't know if things have changed. I think that webinar came out at the end of March.
Right.
So who knows all the things, like you said, they change on an hourly basis these days.
They are. It has been difficult because they are in flux. And I see that Jessica asked a question about, do tenants have to make up those payments? And Jessica, the answer is yes. Again, it's a moratorium on evictions. It's not a forgiveness of payment. So the money is still owed. Hopefully that answers.
Sorry,
the
I wanted to
question.
ask one more question regarding that. You said earlier that you cannot charge late fees. Is that only if someone shows that they've been impacted financially by COVID, or is that for anyone that's late on their rent?
Okay, so it would be for the federally backed mortgage or for someone that's been affected by COVID-19. So if they don't have either one of those things, then yes, you can.
Okay, sounds great.
Good.
Well, thank you so much.
Thank you, Judy, for putting up that resource there for DES. And again, guys, as the hotline, we've started the hotline just for that purpose, so you can get information on how to pursue those benefits. The hotline has been jam-packed with callers right now because today is the very first day and it's servicing 53,000 people. But it'll calm down in the days to come, and hopefully it'll be a great resource for everybody. Judy, anything else? Are you there, Judy?
Yes, I'm here. Yeah.
Okay. Anything else, Judy?
Nope, I don't have anything. Thank you guys very much.
All right.
Someone has a question. Who's that? Oh, Victoria.
Yeah, please.
My comment, but regarding that property that's managed, once they disclose that it's owned free and clear, don't they now have to worry about asset protection? These people have caused problems from the get-go. They could decide to sue the property owner for something.
I'm not sure on what basis they would be able to sue the property owner. Maybe you could expand on that a little bit.
I mean, she mentioned that they're a problem from the get-go and that he's disabled of sorts. So, I mean, he could trip, he could do anything. And then you have a situation where the assets in the property, the equity could be in danger. And we're all just trying to do asset protection, creating LLCs, rental properties. And I'm not an attorney, but I just thought that might be an issue of concern prior to
Right.
forward, as if the property is owned free and clear, and letting the tenants know that. That could be dangerous.
Yeah, I don't, and there's no
ahead.
reason the tenants would need to know
Right.
whether the property is owned free and clear. That's not any sort of information that would need to be shared with them. But you're right. I mean, look, anyone can sue anyone for anything, anytime. That's why Nikki and I became lawyers. No, just joking. But yeah, so look, there's always that risk, but it doesn't sound like there's any more risk, you know, in that situation than there would be otherwise. I mean, if someone's going to trip and fall and make a claim, they're going to do it regardless.
Right. Right.
So, well, thank you, Autumn and Norma and Melinda. We enjoyed this. Again, it's a little difficult for us. I think if you've seen Nikki and I speak before, we're both very interactive and like to have a lot of, you know, communication. And so this format is a little bit of a challenge for us. But Judy, thank you for putting the banner, the flyer up on the screen. And if you guys should have all gotten a special edition of The Voice today in your email that has more information on the COVID-19 Arizona Realtors Relief Hotline. And you can also go to aaronline.com for information in that regard.
Thank you, guys.
All right, guys.
Okay.
All right. Well, thank you all so much. Stay safe and be well.
Thank you.
Okay, you guys too. Bye-bye.
Okay. Bye-bye.